Good morning, welcome to my YouTube channel. My name is David Okon. I'm talking about work in the United Kingdom, and I'm talking particularly about pay and also looking at employer providing unauthorized deductions from wages from their workers. And this law applies to England, and also occasionally is actually applicable to Northern Ireland, Scotland, and also in Wales. Stay tuned, continue watching. Thank you so much for supporting this channel and watching this video and sharing with family and friends. We have been looking about pay, the national minimum wage, and examining the way employers operate the national minimum wage in different ways, and also dealing with problems involving deduction from wages. Who is protected from unauthorized deduction when can a deduction be made? What are wages? What counts as a deduction from wages? And special rules for clients in retail employment. A worker can dispute deductions, actions the employer can take. And stay tuned, continue watching. If you watch this material, watch it in line with the rest of the of the videos which is contained in this series. And from at the outset of this program, I've been looking at income, beginning with help given by the United Kingdom government to individuals in the UK who need help in one way or another in its primacy, employment and pay as to such employment sources of income in the United Kingdom in relation to the cost of living crisis. Income is primarily determining whether or not an individual living in the UK falls into poverty in its extremity or otherwise. There to assess whether somebody's condition is severe, moderate, or just people living in luxury. So I've been exploring these options, these facilities, and looking at policy, politics, and also the economy, looking at development, looking at culture in the UK, and looking at situation in the UK, comparing with the situation across the globe. This is due to globalization, which is an economic and also a political infrastructure, how the globe is being run in the contemporary sense of the word. Stay tuned, continue watching. Thank you so much. And when we are dealing with problems involving deduction from wages, the documents dealing with the legislative protection given to a worker to ensure that they do not have unauthorized deductions made from their wages while they are still working for their employee, their employer, so to speak. This material can be accessed online on Gov.uk, on organizations such as ACOS, and also other material online in different respective organizations. Like I indicated previously, if you need specific help, if you're living in the UK, if you're living outside the UK, then leave a comment below. Let me know what your needs are or what your thoughts are. Stay tuned, continue watching. If the client is no longer working for the employer, there may be other ways of dealing with the non-payment of wages owed. If you're interested in understanding more about payment and wages the wages are payment made in lieu of work done here in the UK and perhaps also in your country, regardless where you live, and therefore you can visit the website and find out more about non-payment of wages if the client has left work, for example. These elements are important in dealing with dispute and problems associated with employment in the UK. The most common problems with wages occur when an employer does not pay the agreed wage, does not pay any wage at all, pays wages late or erratically, paying at random. Sometimes they pay, sometimes they don't pay. So you work not knowing your predicament in terms of income, and that is problematic. Makes deductions from wages, does not give a pay rise when there is a construction obligation to do so. These are factors when you are working or when you are signing a contract for work in your country, especially in the United Kingdom, in Wales, in Scotland, and in also Northern Ireland. All of the circumstances in the previous paragraph can amount to deduction from wages. For example, if a client has not received any wage, that would be a 100% deduction. So a client may be afraid to confront an employer with a wages problem because they fear that they may lose their job, which is something straightforward, commonsensical. If you work for a living, the power equation favors predominantly, conclusively, if I may say so, favoring employer. Not always, but in terms of employee, it is always the case employer has the upper hand in terms of power relations. Leave a comment below. Let me know what your thoughts are in relation to this matter. So a client in this position will have to decide whether to put up with the difficulties that are being caused or whether to try to solve them but risk losing the job. You should discuss with the client whether it might be more helpful if the bureau or similar organization negotiated with the employer on their behalf. Stay tuned, continue watching. Leave a comment below, let me know what your thoughts are in terms of these problems. Watch this video alongside the previous videos. Thank you so much. If you haven't subscribed to this channel, kindly subscribe to support the channel. Subscription is free and it doesn't cost a penny. It takes seconds, doesn't take long at all. The best way to support a content creator like myself is to subscribe to the channel, and so thereby helping a content creator like myself, clicking like, clicking notification bell, so that you don't miss out on new videos being posted on this platform. Thank you so much. Stay tuned, continue watching. An employer who is well known locally or possibly nationally may respond better if the bureau or similar organization were to negotiate on the client's behalf. This is because the employer will want to put the matter right in order to protect their reputation, and so their commercial interests can look more about negotiating with an employer online, on the internet. Stay tuned, continue watching. Leave a comment below if you know how to access internet, your proficiency, everything helps. Every little helps. We live in an age of information. It is therefore of necessity that an individual should have the capacity to access the internet. The internet is a new language of communication, writing, speaking, social media, normal media. It's increasingly more and more the internet and also the social media is a melting pot of facilities, of doing business, of socializing, of learning, accessing knowledge, gaining new ideas. So you are in the right place in relation to this platform, YouTube. So continuing on this discourse, we see that most workers are entitled to be paid the national minimum wage, which is actually entitled by law in the United Kingdom. Check the policy on minimum wage, if any, in your country, more likely than otherwise to be equated or similar with what is involved in the United Kingdom. If an employer does not pay the national minimum wage to a worker who qualifies for it, the worker can take action to enforce it through an employment tribunal. If visiting the internet once again, you can look more about the national minimum wage and how to enforce it. Let us also stay tuned, continue watching to look at the protection from dismissal. As it is, if you do one thing or another, especially doing so in a way which actually offends employer one way or the other, if you work for living, you're more likely than otherwise to be dismissed. The Employment Rights Act 1996 gives a worker some limited protection from having unauthorized deduction made from their wages, and also protects a deduction made from their wages, and also protects a worker who tries to enforce their rights under the legislation. So you find employee who is dismissed for trying to exercise their rights under this legislation can claim automatic and fair dismissal, irrespective of how long they have worked for the employer. We're talking of length of time deadline, which doesn't apply if unfair dismissal is found to have occurred. And so, concern about the deadline may not necessarily apply. We are talking about a situation regarding pay when employer may try to do one thing or another to undermine their rights. When we talk about statutory rights, these are the legal basis in its primacy, as in the primary law, legislation being a primary law, a primary source of law. We give adequate power and rights to employer, and also we have could be employer as well. So an employee who is dismissed for trying to exercise their rights under this legislation can claim automatic and fair dismissal irrespective of how long they have worked for the employer. In normal circumstances, you need to have worked for about 2 years to have rights of claim in terms of dispute with the employer. Under these circumstances, that is ignored, and as to the extent that you work for that employer, you have rights ab initio. So this is because they have been dismissed for trying to claim a statutory right thereat. So I want to mention the statutory right. This is very primary, this is very important, therefore giving adequate right to an employer and also to an employee. Under these circumstances, the right given to employee. Leave a comment below, let me know what your thoughts are in relation to this material. Stay tuned, continue watching. Normally an employee has to have worked for the employer for a qualifying period before they can claim unfair dismissal. More about dismissal, I will talk about the qualifying period. Normally, like I said, it tends to be 2 years minimum before you have any right at all. But under this condition, that is ignored, is overlooked by the legal authority, by the tribunal, and so on. So an employee has a right to challenge unfair deductions made from their wages and can't be dismissed for doing so. Workers aren't protected in the same way, but they might be able to claim unfair treatment if they lose out on future work as a result of challenging a pay deduction. This is interesting because there is a difference between a worker and an employee. So workers having more right in law, employees having right in terms of employment statuses, employee having more right than a worker under these circumstances. However, there may be right, automatic right for workers also if the illegality or the treatment has been suffered because the employee, the worker, has challenged the pay in deduction. These are fine points of law which need careful attention, which are very subtle in terms of employment law, leave current law, and let me know what your thoughts are in terms of this material. So it's illegal for workers to suffer detriment at work as a result of exercising certain legal rights. If a worker has had wages deducted so that their pay has fallen below the national minimum wage for that week, they could challenge their employer's failure to pay the minimum wage. This way, if they lose out on future work because of the challenge, they could claim compensation through an employment tribunal. Stay tuned, continue watching. Leave a comment below, let me know what your thoughts are. Click like, click notification bell to help support this channel. Also reminding you of any new posting. Subscribe to this channel to support it. Subscription is free. It takes only a second. Thank you so much. Stay tuned. Continue watching. So therefore, they could claim to be suffering a detriment as a result of asserting their legal right to the minimum wage. More about what should be contained in an itemized pay statement, more about this mission as well, as you could find this as often online if you access one website or another, gov.uk being the primary, the most commonsensical one to access to find information of this sort. Whether you live in the United Kingdom or you live away from the United Kingdom, there could be a lot of similarity between the two. About learning as know the boundaries, you can always learn what happened in the United Kingdom and compare the same with what might or might not happen in your country. Let us also look at other ways to challenge deduction. So, in an attempt to change the wages the client receives will be a change to their terms and conditions of employment, and if they have not agreed to the change, this will be a breach of contract. We are talking about contract signed freely between employer and employee, which could be broken if employer behave in one way or another. Under these circumstances, it would be a breach of contract in favor of the employee and also against an employer. Leave a comment below, let me know what your thoughts are in relation to this matter. Who is protected from unauthorized deduction? We are talking about unauthorized deduction as a topic, as a theme, looking at different elements of law in the United Kingdom in relation to employment law per se, in respect of pay, particularly the national minimum wage, which is statutorily obligating to employer to pay employee the same in terms of UK law. Stay tuned, continue watching, and leave a comment below, let me know your thoughts. So, which workers are covered by the legislation? Let us look at employers who must not make unauthorized deduction from the workers' wages, and therefore doing so may incur some illegality, may actually operate some illegality to incur consequences. So looking at situations where workers, including workers suffering, this situation would include employees, apprentices, zero-hour workers, casual workers. We are talking about employment status, so agency workers. as we mentioned in the other videos in the opening of this conversation. Stay tuned, continue watching. So, some people who are described as self-employed can also be workers. They will probably be workers if they do the work themselves and can't send someone else. The law calls this doing the work personally, aren't doing the work as part of their business, like where the person using their service is a client or a customer. Stay tuned, continue watching. If you're not sure if you are in a situation whether or not you are a worker, you can check also online your employment status. Take this example as a pointer. Kat is a carpenter working for a building company. She's described as a self-employed contractor, but she can't subcontract the work to anyone else. She doesn't work for anyone else. She probably is a worker. Grant is a bookkeeper who advertises his service. He is advertising these services and has several different clients. He does the work for each client himself and is doing the work as part of his business, so he probably isn't a worker. Stay tuned, continue watching. Thank you so much. So therefore, continuing, let us look who a worker is. A worker must be working or willing to work. Like some of the sub-characteristics. Workers should be paid in full for their contracted hours if they are fit and willing to work, unless their contract says they don't have to be paid. It's all in the contract. So somebody in that situation in having a contract will set out the situations where the employer doesn't have to pay them. For example, if they are being laid off, if they are put on short-time working, if they've been suspended from work on medical grounds. Stay tuned, continue watching. Thank you so much. So if a worker is fit but not willing to work, the employer doesn't have to pay them when they should be working but aren't working. For example, if they take a holiday, even though the employer has refused their holiday request. Stay tuned, continue watching. So therefore, when can a deduction be made? Under these circumstances, unless one of the exceptions applies, a deduction from a worker's wages can only lawfully be made if it is authorized by a statute. For example, deduction for tax and national insurance contributions, or payment of student loans, and deduction following a court order, such as under term of earnings order, earnings arrangement in Scotland, or it is authorized by the contract of employment. Stay tuned, continue watching. This needs to be in writing and could be an implied term of the contract or contained in another document. An employer must have notified a worker in writing of the term before the event which gave rise to the deduction. For example, if the term is written in the staff handbook, but not in the individual employment contracts, the employer must ensure that the employee has either received a copy of the handbook or been notified in writing about the existence of the term and its effect before the event which gave rise to the deduction, or the worker has previously given their written consent to the deduction being made. Stay tuned, continue watching. Thank you so much. We talk about employment, we talk about pay in relation to the national minimum wage and the dispute, the problems arising there. In addition to the rules above, there are extra rules for workers in retail employment. We are talking about workers as a person with a particular employment status in a retail sector. In the United Kingdom, if an agency worker has a contract with an umbrella company, the company may be able to make lawful deduction for employers' national insurance contributions and admin or service charges. Check what deduction can be made for agency workers under an umbrella contract. Talking about an umbrella contract. So the worker must give their written consent to the deduction prior to the event which gave rise to the deduction. Where the written consent relates to the stock shortages, the consent must have been given before the shortages arose. In any case, the worker must have given consent via a written term in their contract, verbal term in their contract, as long as they have been notified in this term in writing. A contract can be explicit, it can be also implied. If you comment below, stay tuned, continue watching. So, well, there is also a situation of separate written agreement under these circumstances. So, instead of making a deduction from pay, the employer may ask the worker to make an equivalent payment. And any such payments are also covered by the conditions in which the deduction can be made. Leave a comment below, stay tuned. Thank you so much. Where an employee does not pay any of the wages which are properly owed to a worker, this will also be counted as a deduction. In this case, 100% deduction will have been incurred by the employer against the employee. So let us look at industrial action. Stay tuned, continue watching. Thank you so much. Subscribe to this channel if you haven't subscribed. Leave a comment below and click the notification bell. Click like. Watching this video, share with family and friends. Thank you so much. Continue watching. So a worker is not entitled to be paid for any period during which they are taking industrial action, and the employer is entitled to deduct and pay for the time the worker is on a strike. The High Court has stated that the amount the employer can deduct can only be the amount that a worker could recover in a claim for unlawful deduction from the wages. For someone working 365 days a year, this would be calculated on the basis of 260 working days. For example, someone working full-time who was on strike for 2 days would have 2 of the 260 of their pay deducted for those strike days. So strikes would constitute deductions. Exception to these rules. Stay tuned, continue watching. So an employer can make certain deduction or ask for payments without having to fit into the rules governing when deduction can unlawfully be made in case of, for example, overpayment of wages or expenses. You can also find more about overpayment of wages, and also deduction made or payments received by the employer as a result of a statutory disciplinary proceedings. Disciplinary proceedings in certain employments such as the police and fire service, and not disciplinary proceeding in private employment. Stay tuned, continue watching. Thank you so much. Also, deduction made or payment received by the employer because the worker took part in industrial action. Stay tuned, continue watching. Thank you so much. So also in situation where a deduction made or payment received by the employer after the court or tribunal has ordered the worker to pay a certain amount of the employer to the employer as such. Thank you so much. Continue watching. Stay tuned. Where an employer in response to a worker's claim for unlawful deduction of wages says they made the deduction for one of the reasons listed above, the employment tribunal should not reject the worker's claim out of hand before reviewing the evidence in order to establish whether it has jurisdiction. Stay tuned. Continue watching. Thank you so much. Looking in here, what wages amounts to, what are wages. If you work for a living, stay tuned. If you work for a living, leave a comment below. If you don't work for a living, do likewise. Thank you so much. We are in the UK, looking at work, looking at employment, pay, minimum wage, and that, and also situation pertaining to relationship between employer and employer in terms of national minimum wage, whether they are paid, whether they are deducted, whether they are lawful or otherwise. So there are specific definitions of what constitutes wages in terms of definition when dealing with issues about deduction from wages under subsection 13 to 27 of the Employment Rights Act 1996. Articles 45 or 59 of the Employment Rights Northern Ireland Order 1996 rather. This definition does not apply to wages in any other situation. Wages, therefore, including any fee, bonus, commission, or any other payment made because a worker's employment, either under the contract or otherwise. This definition does not include payments in respect of expenses incurred in carrying out the employment. A bonus received by a worker which is not part of their contract is counted as wages on the day it is received. A non-contractual discretionary bonus is counted as wages when it is declared. There are special rules about holiday pay. Stay tuned, continue watching. Thank you so much. And also any payments ordered by an employment tribunal in connection with an order for reinstatement or re-engagement will be actually acknowledged. This will most often be payment of wages for the time between dismissal and also order for reinstatement or engagement. Stay tuned, continue watching. We are in the UK talking about work and also the issues involved if you are working for a living with an employer. Thank you so much. Any payment ordered by an employment tribunal for the continuation of the contract when a worker is claiming dismissal because of trade union activities is also looked at. Statutory payments in lieu of wages, for example, grantee payments for the time off for trade union work or looking for a job, payments while suspended on medical grounds, and protective words in connection with redundancy, and also including statutory sick pay, statutory maternity pay, statutory paternity pay, statutory adoption pay, and also statutory shared parental pay can be looked at online. If you are interested, if you're not interested, stay tuned, continue watching. Benefits in kind, which have a cash value and which can be exchanged for money and goods or services. For example, luncheon voucher. We have looked at these elements previously. We are looking at similar elements again in relation to deduction in one way or another from wages. Let us look at bonus pay and commission. Bonus pay and commission count as wages. If commission is overdue at the end of the worker's contractual employment, the worker can make a claim for the unpaid commission in the same way as they could for any wages owing to them, provided the employer does not have a legal right to withhold the commission. More about claiming money owed by the employer. Stay tuned, continue watching. Thank you so much. So therefore, if a bonus payment are made, this will count as wages. A deduction from bonus paid will therefore be unlawful deduction of wages, provided the employer does not have the legal right to take the deduction. However, the Court of Appeal has found that unlawful deduction claims can only be applied where a specific sum of money is owed or an identifiable sum can be arrived at, as seen here in this material. Leave a comment below. Let me know what you think about this situation. So the Employment Appeal Tribunal has held that an employee is entitled to a discretionary and non-contractual bonus as soon as the bonus has been declared. It will therefore count as wages from that moment, and if the employer then fails to pay it, this will be an unlawful deduction from wages. Stay tuned, continue watching. Thank you so much. We are looking at tips and services, service charges. We are mindful of how employees are paid in the United Kingdom. Are looking at different elements. Let us look at cash tips and also a tip in cash, which is voluntarily given by a customer to a worker. It's a gift by a third party to a worker, and so is not wages paid by the employer. These are some of the classifications. Stay tuned, continue watching. I'll leave a comment below. Let me know what your thoughts are in relation to these matters, because they are not wages. They are not covered by the Employment Rights Act in Northern Ireland. Also, if the employees' tips are pooled and the employer takes money from them before distributing them between the employees too. For example, make have money is missing from the till. This is not an unlawful deduction of wages, and because such tips are not wages, therefore let us look at tips. Stay tuned, continue watching. Leave a comment below. Let me know your thoughts, and let us also look at tips by check or credit card. These are methods of payment. They are forms of money which are paid other than cash. If a tip is paid by a customer adding an extra voluntary amount of their credit card or check payment, it becomes the property of the employer. The employer can choose whether or not to distribute the tips to the workers. If the tips are shared out to the workers and paid through the payroll, this payment from the employer to the workers forms part of the workers' wages and is therefore covered by the Employment Rights Act in Northern Ireland. We're talking about order. Therefore, stay tuned, continue watching from October, the 1st October 2009. Employers cannot use tips to make up the workers' wages to the national minimum wage. Stay tuned, continue watching whether the tips are paid through the payroll or not. So, if an employer distributes tips to workers, this must be paid on top of the national minimum wage. However, tips paid in this way, in addition to the national minimum wage, will still form part of the workers' wages and are therefore covered by the Employment Rights Act. In I order in relation to whether deduction can be made from them. Let us look at the compulsory services as charges. If the service charge is compulsory, that is, it is added automatically, and if it is added automatically to bills, it is the property of the employer who can allocate it as they wish. The worker may add a clause in their contract specifying they are entitled to a share of the service charge. And stay tuned, continue watching. Let me know your thought in terms of this facilities working in the United Kingdom. If the worker is entitled to a share of the service charge, and it is paid through the payroll. It forms part of their wages and is covered by the Employment Rights Act and I order. Therefore, the employer cannot change how the service charge is shared out without the consent of the employees. If the change would result in an unauthorized deduction from wages. Stay tuned, continue watching. Thank you so much for your attending and also participating in this facility. And let us look at His Majesty Revenue and Customs guidelines on this issues. You're talking about the tax office in the United Kingdom. When we talk about the His Majesty Revenue and Customs HMRC, which has produced a leaflet giving further guidance on tips, including how they are treated for income tax, national insurance contributions, and minimum wage. It is called the tips, gratuities, service charges, and trucks. E24 and it is available from the HMRC website at www.hmrc.gov.uk. Thank you so much for coming, for participating. Let us look at statutory sick pay, statutory maternity pay, statutory paternity pay, statutory adoption pay, and statutory shared parental pay. Therefore, looking at these aspects, the Expert Advice Team EAT has decided that employment tribunals do not have jurisdiction to decide whether a worker is entitled to SSP, SMP, SPP, SUB, or SHPP, like as referenced above, and that such decisions must be made by the Revenue and Customs HMRC instead. So if HMRC decides that the worker is entitled to this pay and then the employer does not pay it, the worker can make a claim for an unlawful deduction from wages for the amount owed. Stay tuned, continue watching, and thank you so much. So therefore, continuing,
some see the original, mighty the god, the magical radical. Hey, representing my magical, young Jose, come million. Jamaica wacha, that difta, kina teach me kenyo Jamaica kopa. That wacha, kina damage me kenyo Jamaica wacha. That difta, kina teach me kenyo Jamaica kopa. That difta, kina damage me kenyo. Gangsta the kamele. Come on, there we are there for the bed. The heaven they say you're my baby. Every day I call you my door, you're my treasure. Baby got your machina, yo. Baby quackana, yo. Baby chop on cola. Baby got your machina. Baby got your quara. You are say bandana. You must say bandana. You must say bandana. Baby got your.
So also there is something known as pay in lieu of notice and garden leave. Stay tuned, continue watching. We are talking about employment in the United Kingdom, pay and the issues surrounding pay in the United Kingdom when you are working for a living. And there is only one circumstance where a non-payment or pay in lieu of notice may be treated as an unauthorized deduction. This is where the worker and an employer agree that the worker is given notice terminating the employment. The employer will pay the worker for the notice period, but the worker will not work during that time. Stay tuned, continue watching. Thank you so much. Now, this is where a worker and an employer agree that the worker is given notice terminating the employment. The employer will pay the worker for the notice period, but the worker will not work during that time. Stay tuned, continue watching, and leave a comment below. Thank you so much for your attention. Attending this session. This is often called garden leave. Stay tuned. Leave a comment below if you know what garden leave is. If garden leave is agreed and the employer does not pay or some of the agreed money, the worker can claim that this is an unlawful deduction. Garden leave is pay in kind, pay in lieu of one thing or another. No other type of pay in lieu of notice could account as wages as well. This means that there is a non-payment or an underpayment or pay in lieu. A worker can not make a claim for an unlawful deduction. They will have to make a breach of contract claim instead at an employment tribunal or sue for breach of contract in the county court, sheriff court in Scotland. If the employer withholds the worker's wages because the worker failed to give the appropriate notice, this would be an unlawful deduction. We'll talk about payment in lieu of notice. Stay tuned, continue watching. Leave a comment below, let me know what you're thinking. So let us look at what counts as a deduction from wages, and therefore where the total amount of wages paid by an employer to a worker is less than the total amount that should be paid under the contract of employment for that period, pay period. The amount of the shortfall is a deduction. We are trying to look what a deduction might or might not look like under different headings in employment law in terms of pay, also including national minimum wage, and what is amounting to pay in substance or also in kind. The employer has paid no wages at all. That counts as a 100% deduction. Stay tuned, continue watching. Thank you so much for your attending this session. Continue watching. The following can all count as a deduction from wages: failure to pay statutory sick pay, statutory maternity pay, statutory paternity pay, statutory adoption pay, or statutory shared parental pay. Stay tuned, continue watching. Leave a comment below if you have been in this situation before. If you're a parent, if you're a joint parent, so therefore, failure to pay any wages owing include accrued holiday pay. Also, failure also to pay working tax credit. We discussed these different elements in the other videos. These are benefits in kind and in relation to employment under this circumstance. So also a cut in the rate of wages paid, therefore amounting to deduction or failure also to pay altogether, a cut in contractual overtime pay or hours, a failure to pay, or a cut in bonus payment or commission payments. Late payments of wages also can be considered under these rules and also under this obligation. Let us look at non-payment of holiday pay as a function. So, following a case in the European Court of Justice (ECJ), the House of Lords has decided that a worker on long-term sick leave continues to accrue statutory holiday while they are off sick. Stay tuned, continue watching, leave a comment below, let me know what you think. So the House of Lords has also decided that non-payment or underpayment of holiday pay can be treated as a series of unauthorized deduction from pay under Section 13 of the Employment Rights Act 1996. The House of Lords is a type of court. During the time when they were still court, it's now changed into independent body in terms of court structure. And also hierarchy in the United Kingdom. This is important for determining the time limit by which a claim for unpaid statutory holiday pay can be made. If a claim for unpaid or underpaid holiday pay is made within 3 months of the last non-payment or underpayment, earlier non-payments or underpayments can be included in the claim as a series of deductions. It doesn't matter if there was a gap between the underpayments as long as they are part of the series of deduction. Stay tuned, continue watching. Thank you so much. So if you are in a situation where if you are your employer says you aren't entitled to holiday pay, then you would be someone who might be able to make a tribunal claim. So the deadline for someone in your position claiming depends on whether you have left your employer. Sometimes people leave work, some people, and that also affect the way you make claim or the way you don't make claim. Check what you could do if you should do check what you should do if your employer says you are not entitled to paid holiday. You can check this online if you are in a situation one way or the other. So the employee should raise a grievance first if there is time to do so within the time limit for making a claim to a tribunal. We talked about time limit, which is very important. People should often check time limits, because in these cases, in these claims, there are always deadlines, which is so necessary. So late payment of wages, let us look at late payment of wages. If you are paid late, what does it mean? If an employer is late paying wages, there is a deduction of wages during the period between the date when the wages should have been paid and the date on which they are actually paid. So if you are paid late, that is counted as a deduction from the day you were not paid and from the day when you were paid late. So this is an important point of law and policy, which is really important for people living in the United Kingdom. If you also live outside the United Kingdom, this is because a deduction of wages arises on any occasion when the total amount of any wages that are paid by an employer to the worker is less than the total amount of the wages that they are properly due to the worker on that occasion. The deficiency is treated as a deduction from wages. Leave a comment below and let me know your thoughts on this matter. In a particular case, an employee often had her wages paid a number of days late, which meant she had difficulty paying her bills. When her wages were not paid on time, she made numerous phone calls to her employer trying to obtain payment. Stay tuned, continue watching. She had to take time off work caused by the financial difficulties of being paid late. When she returned to work, she was dismissed. She claimed unfair dismissal on the ground that she had been dismissed for trying to assert a statutory right, namely that she had had an unlawful deduction made from her wages. The Employment Appeal Tribunal ruled that the employer's failure to pay wages on time amounted to deduction from wages, and that the employee's phone call to the employer asking to be paid meant she had asserted her statutory right. The dismissal was therefore automatically unfair, and the employee did not have to have worked for a qualifying period to make the claim there. This is important for people who might be working under employer who are rather corrupt, who does one thing or another, exploiting laws here, laws there to abuse the employer. So leave a comment below if you are in this, you have been in this situation before. Let me know so that I can have a conversation in one way or the other. So therefore, a worker may also be able to claim for any consequential losses they have suffered as the direct result of an unlawful deduction of wages, such as bank charges or interest accrued. Stay tuned, continue watching. Let us look at special rules for someone in retail employment. If we can, in addition to the rules about when deduction from pay are allowed, there are extra rules covering deduction from the pay of workers in retail employment to cover cash shortages or missing stock, these extra rules limit the deduction that can be made on any one payday to 10% of gross wages. Such deduction can be made where there is a pre-existing term in the contract allowing it, where there is some other written agreement arising. What is retail employment? So retail employment is work which involves selling or supplying goods or services directly to members of the public, co-workers and other private individuals, or collecting any money payable as a result of someone else selling or supplying goods or services to members of the public, co-workers and other private individuals. Stay tuned, continue watching. Thank you so much. So retail employment therefore covers such people as shop assistants, petrol station cashiers, bank and building society cashiers, waiters, bus conductors, and car park attendants. Stay tuned, continue watching. Thank you so much. So let us look at what counts as wages in retail employment. The definition of wages from which deduction can be made is the same as that in other employment. Stay tuned, continue watching. So what deduction can the employer make? We are going to look at this point the next time we meet. Thank you for watching today, and subscribe to this YouTube channel if you haven't subscribed. We will continue from where we left today. Watch the other videos, watch this one also, and click like, click notification bell, leave a comment below if you watch. Share with family and friends, and remember to subscribe, to support. Subscription is free, it takes a second. Thank you so much. See you in the next video. Thank you. Bye bye. So also there is
MVC record.
Brava Jesus.